the candidate's name is blank. So that's precisely what you were doing, was going out and collecting signatures, getting electors to sign blank nomination forms, not candidate nomination forms.
And I have no power to change the design of the ballot.
Well, sir, with respect, you do have the ability to stop your committee's actions from blowing up our ballots to achieve a political goal where there is no political consensus in this country to change our electoral system.
And have you been given any warnings? Have you been given any reprimands? And have you been threatened with charges by Elections Canada?
This guy's garage. Like and subscribe.
I call this meeting to order. Welcome to meeting number 5 of the House of Commons Standing Committee on Procedure and House Affairs. Pursuant to Standing Order 108 Sub 3, the committee is meeting in public on the actions of the Longest Ballot Committee in recent Canadian elections.
Thank you, Mr. Chair. Mr. Shukevich, you have operated as a key organizer for the Longest Ballot Committee and served as the official agent for many of the candidates affiliated with the Longest Ballot Committee, correct?
That is correct.
And your brother, Kieran Shukevich, also is an organizer with the Longest Ballot Committee, correct?
That's correct.
Okay, and I want to ask you some questions about the recruitment of candidates and the collection of nomination signatures for the Longest Ballot Committee. When you and other organizers from the Longest Ballot Committee were collecting signatures, at times electors would have been presented with multiple nomination forms to sign simultaneously.
That's correct.
Okay. And as you went about collecting signatures and recruiting candidates, the Longest Ballot Committee told prospective candidates that they didn't have to worry about collecting signatures because the Longest Ballot Committee already had collected the 100 or more signatures needed for them to get onto the ballot. Isn't that true?
No, that's not true. You have that a little bit backwards. So we recruit candidates, we get all their names, and then we collect signatures for them. We're not like just collecting signatures for people who said they don't want to run.
So I have a video
Okay.
that you posted on YouTube to the Longest Ballot Committee on August 18th, 2024, in respect of the LaSalle-Imard-Verdun by-election, in which you state that if we're going to break the record for the longest ballot, we need everyone to sign up as soon as possible. We've already collected 100 nomination signatures for you. All you have to do is follow the instructions. So, in fact, you and other organizers for the Longest Ballot Committee were going around with nomination forms that didn't have candidates' names on them. Isn't that correct?
That is not correct.
I'm going to stop you there, Mr. Shukevich, because I have a tweet that was posted by the Longest Ballot Committee on January 22nd, 2024, of you, of Kieran, and of I believe, a Glenn McDonald.
Yep.
And when you look more closely, this is you. We see where the candidate's name is on the nomination form with signatures. The candidate's name is blank. So that's precisely what you were doing, was going out and collecting signatures, getting electors to sign blank nomination forms, not candidate nomination forms.
That is not accurate.
Well, I just present you with evidence, documentary evidence, that establishes that, in fact, it is accurate. And I want to caution you, sir, but you're testifying before a parliamentary committee, and you have an obligation to answer my questions fully and truthfully. And if you fail to do so, sir, you can be held in contempt of Parliament. And I want to make clear to you that I will not hesitate in using all of the tools available to hold you accountable should you not provide truthful and accurate answers, which up till now you have not. So I'm going to give you one last opportunity to confirm on the record that you went about collecting signatures from electors where the candidate's name was blank. That's what you did, right?
No, that is not accurate. If you would give me a chance to actually respond, you've made quite a few incorrect assumptions here. Where would you like me to begin? With the AI doctored images or with your misunderstanding of what sign up means? So in that video, when I say sign up, what I'm referring to is that these are candidates who have already expressed that they want to run. We then collected their signatures with the candidate name at the top. Obviously, that's the rule.
Candidate's name was not at the top.
It was at the top. I was there.
Yes, it was not at the top.
And then when we say we already have your signatures, you need to finish signing up, that is referring to fill out your forms, book an appointment with the returning officer to do your declaration. This is very straightforward. You have it kind of mixed up. If you want to talk about those AI manipulated photos, I'm happy to do so.
I don't have anything mixed up. What I have are
Respectfully, you do have that mixed
a
up.
YouTube video.
If I can for a moment, Mr. Shukevich.
Yeah.
We operate here on a position that members of Parliament are honourable, and to accuse a member of Parliament of doctoring images, I think you should tread very carefully in that. I don't know about these images, but I'm giving you a warning in terms of I don't find it funny, sir. I don't think you should find it funny either. Mr. Cooper is correct in what Parliament can do, and perhaps you don't have respect for the individuals sitting at these chairs. Please have respect for the institution and the electors that put us here. Sorry, Mr. Cooper. I think we stopped about 30 seconds.
ahead.
No, we have never collected signatures with blank candidate names. The Chief Electoral Officer has already testified to you that there's no credible evidence of any
Chief Electoral Officer in his testimony said that your committee initially got caught doing precisely just that. That was his testimony.
Respectfully, Mr. Chair, that it was not his testimony. His testimony was that we collected without an identified candidate, which is true. We wrote all candidates were in the candidate field, and we got people to sign. We said, would you be willing to nominate any and all candidates? It was not
That's
Mr.
what
Cooper.
you did. You just admitted it.
No.
Thank you, Mr. Cooper.
The concern that I have on this committee is the rights of people to vote. Can you explain that point, that the management of election highly localized and the challenges that were faced and the possible challenges to people's right to vote?
Yes. What's remarkable about Canadian elections is how amateur they are and how well run they are. Right? That all of our local polling places are staffed by people who are paid, but they're essentially temporary people working to serve our democracy. And they're doing it in kind of the most important civic activity that we do. So I've always found that kind of interesting. But the challenge is that if voters walk into a polling place and they're confronted by 1,000 names on a ballot or 200 names on a ballot, it makes it challenging for election workers to explain the ballot to them, and it makes it challenging for them to help the voters do what the voters intend to do. Voters are not there to cast a ballot for some obscure person who got onto the ballot through a signature harvesting exercise. They're there to vote for one of the major parties, or maybe a real independent local candidate or a local notable, or a small party that's trying to break through. So if voters are going there and they're told, look, voting is straightforward, trust us that you can do this, and suddenly they're confronted with a meter-long ballot, it erodes, at least at the margin, their sense of democratic efficacy, and it makes it hard for the people running elections. I'm sure it's frustrating to explain where to look for the people who are actually running for office on that ballot.
If I can interject, I do apologize. Mr. Lewis is over time.
Yeah, thank you, Chair. Just to confirm with you, Mr. Shukevich, in your submission to the committee, it said that whoever wrote the submission, I'm not sure if that was you, said that they watched the testimony from the Chief Electoral Officer last week. So just wanting to confirm if that was you that authored that document or not, and did you watch the Chief Electoral Officer's testimony last week?
Yeah, my brother and I wrote that document. And yeah, I watched the testimony last week.
Okay, so you'll have seen then that the Chief Electoral Officer testified last week that your actions in various constituencies, whether it be general or by-election, affect every voter's access to vote, but the actions of your organization particularly hurt and block the ability of seniors and folks with disabilities to be able to cast their ballot. Those who are born with additional needs and the seniors who built this country should not have barriers put in their way by a political stunt that has no motivation or request from the public to change our electoral system. So what kind of an organization would try to prevent those most vulnerable in our society and our seniors from being able to access their constitutional right to vote?
Yeah, Mr. Chair, that's a great question. So as we all know, the design of federal ballots is prescribed by the Election Act, which is written by you MPs. So I'm not aware of any documented cases of people actually being prevented from voting because of too many candidates. I am aware of existing accessibility concerns surrounding the voting process. The Canadian National Institute for the Blind gave a series of recommendations to this very committee on improving accessibility when Bill C-65 was being discussed. I would point out that none of their recommendations have been implemented by you, and I would also point out that none of their recommendations involved arbitrarily restricting citizens' rights to run as a candidate. So I'm not an expert on accessible ballot design, so I would suggest that you talk to the disability advocates for that.
Well, thank you, Chair. I think the Chief Electoral Officer has spoken to disability advocates and has heard multiple complaints. The number of complaints about this election were higher than it has been before, which was also presented as part of his testimony. So whether or not it's the end goal of your organization, this is the result that people had a more difficult time casting their ballot in this election, both in the Battle River Crowfoot by-election and in the general election, than ever before. And they were predominantly seniors who had to wait in longer lines and found the sometimes meter-long ballot more inaccessible, or people with disabilities, including, as you mentioned, people that are vision impaired. So these actions have caused people not only to be unable to wait in the line longer to vote, but also required in many cases no longer their ability to privately vote because they required assistance in the ballot box in order to manage the ballot that your organization forced to be so unwieldy that they could not manage it on their own. Why would you take these actions? And what do you have to say to those Canadians who had their privacy breached because of their inability to manage the ballot on their own because of your campaign's actions?
Mr. Speaker, I would, again, I don't design the ballots. The ballot design is written in the Elections Act, which means you MPs actually design the ballot. And if the Chief Electoral Officer was following the will of Parliament, then it actually would have been twice as long in those two-column situations. Of course, for operational reasons, understandably, he had to make emergency amendments to the Elections Act in order to not make it like 4 meters long. So yeah, if you're concerned about accessible ballot design, I strongly suggest you talk to disability advocates, because I'm not an expert on this, and I have no power to change the design of the ballot.
Well, sir, with respect, you do have the ability to stop your committee's actions from blowing up our ballots to achieve a political goal where there is no political consensus in this country to change our electoral system. The professors already noted it. You have a Liberal Party that campaigned on it in 2015 and then backed away from it because they recognized that there was no willingness to change the electoral system from anywhere near a consensus or even close to a majority of Canadians. So you're wasting everybody's time and in the process harming some of our most vulnerable Canadians' ability to participate in Canada's democracy.
Okay, I will interject there, as it is 5 minutes. Perhaps, Mr. Shukevich, you can answer that in subsequent questions that may come up. So.
I just want to hear your thoughts on the risk of foreign influence through political financing, and what you think are the many vulnerabilities that exist in our political financing regime right now.
It's a good question. It's one on which I'm not an expert. So you will hear from other people who are experts on it. I think that the biggest vulnerability is a little bit of what I articulated to Mr. Lewis, but put slightly differently, that just as the costs of communicating go down, the ability of people to use small amounts of money to influence our elections is greater than it was before, right? And the idea that it would be impossible for a person from Russia to put an ad on the CBC or CTV, right? But it's not impossible for them to put one on Twitter. So the permeability of platforms versus broadcast networks and radio networks is, I think, probably the most serious vulnerability. That's less about where the money's coming from, and it's about the ability of money to be put to speech on these platforms.
Well, thank you, Mr. Chair. I always appreciate hearing from Canadians, particularly those who think we shouldn't have politicians making laws. They think that other people should be making laws other than people who are actually elected and accountable and re-accountable to the electorate. I fail to see the logic, to be quite frank with you, given the fact, as my colleague Mr. Jackson said, even when the Liberals had a majority in 2015 to 2019 and proposed electoral reform, the Canadian public actually, through their elected representatives, decide whether or not something is going to be palatable. And that's how we actually go through the sausage-making effort of making laws, regulations, including laws regarding our elections being at this particular committee. Anybody with a basic understanding of a civics class would know that. But I'm going to ask my first question to Mr. Loewen. Mr. Loewen, in 2017, an Alberta court decision ruled that a provision in our electoral laws requiring a $1,000 deposit was a violation of the Charter on Rights and Freedoms. Do you, first of all, I think you would agree that elections are serious business. I don't think there's a more serious thing that a Canadian can do than cast their ballot in the democratic process. We're approaching Veterans Week and Remembrance Day. Over 120,000 Canadians have paid with their lives in order to make sure that we can all do this. This is serious business. It's about as serious business as it gets. I always interpreted that $1,000 requirement to be something put in place to make sure that unserious people weren't able to just get their name on the ballot. Do you think the government made a mistake by not challenging or trying to challenge that decision made by an Alberta court in 2017?
I have to confess I'm not deeply fluent with the case, so I don't know the jurisprudential argument for it. It strikes me as an entirely reasonable limit of $1,000. What I will say is that Canadian elections are cheap. I know it seems like perhaps I don't know actually whether MPs feel like they're spending a lot of money or not, but I do know that many of you raise more money than you can spend, and we also have examples of candidates who can win without spending a lot of money. I think it's great that for the most part we've put pretty serious caps on our election spending, so that who wins is not determined purely by who raises more money. Now, where those exact limits are, Mr. Calkins, I'm not sure, but I do think that that $1,000, clearly that $1,000 deposit plus changes in the signatures, or the ease of signatures, and the fact that one could be an agent for multiple candidates, does make the ballot probably more permeable than is desirable, as evidenced by the ballots in the last election.
Thank you for that. You've answered the second part of my question as to whether or not you think that should be put back in place. I don't know if there's a possibility to do that now, given the fact that I think the time for challenging that court decision has elapsed. Do you think that in order to protect the integrity of our electoral system and treat it with the seriousness that it deserves, that this committee should look at the definition of registered third parties and to make sure that this is obviously a very organized effort? Is there anything that you would advise us to do with the definition of a third party?
Yes, I mean, I think that I think this is critically important, and I'll note that your party has a history of being the least supportive of regulations on third parties. And I'm not saying it to score a point or anything, but I think I raise it, Mr. Calkins, to note that I think we've come to a consensus in the country, even among your party, that it's good to have elections contested principally among political parties without huge outside influence. And I think that's a good thing. And I actually changed my own opinion on it over time. So as the cost of advertising changes and as the tactics of third parties change, I think it is worth asking whether legislation is fit for purpose to achieve what the overall animating principle is in Canadian elections, which is that elections should be a conversation between parties and voters without the cacophonous entry of hundreds of other people into that conversation.
Thank you very much. Now to Mr. Shushevich. The Chief Elections Officer, Mr. Perot, told the committee that people should face penalties for signing multiple nomination papers. Would you agree with that statement?
I believe that was one of his suggestions. I don't really see a reason for that. I don't really see the logic in it. Personally, I prefer it when there's more than one candidate on the ballot. So I should be able, as a voter, to nominate more than one candidate.
You're aware that Section 480.1, subsection 1, says every person is guilty of an offense who with intent mislead falsely represents themselves to be or causes anyone to falsely represent them to be a candidate or a person who is authorized to act on a candidate's behalf. Would you agree that asking somebody to sign a nomination paper that has all candidates written at the top or no candidate's name would be a false representation under the Act?
No, I'm not a legal expert, but I don't believe it was. Of course, the returning officer determined that wasn't acceptable to be, like the candidates couldn't get accepted based on those forms, and so they were refused, and that's fine.
Also in the Elections Act, Section 482.1, every person is guilty of an offense who obstructs or hinders or knowingly makes, either orally or in writing, a false or misleading statement to the Commissioner of Elections of Canada Elections or any person acting under his or her direction, while the Commissioner or the person acting under his or her direction is exercising or performing powers, duties, or functions conferred or imposed upon the Commissioner under this Act. So that's obstruction. Do you think any of the actions of your committee have actually obstructed and met the definition here for obstruction under Elections Canada? And have you been given any warnings? Have you been given any reprimands? And have you been threatened with charges by Elections Canada?
Certainly not to any of those questions. I've never been reprimanded and have no intention of misleading anyone. We have nothing to hide. We do everything by the book.
My colleague,
Thank you very much, Mr. Calkins.
Thank you, Chair.
I will exercise my ability as chair to ask a question, and it's picking up on what Mr. Calkins was alluding to with appointing people who would seemingly not be accountable. I know in our system, and I think you even spoke about it in terms of the Elections Canada being respected. The executive appoints a nominee to be the head of Elections Canada, and an organization that's independent like the RCMP is appointed and then is accountable to Parliament. It worries me that you're proposing an agency that may not be accountable. Who are these individuals who would be appointed to this committee? I guess is my question, if it wasn't going to be politicians or the executive who was going to make that appointment.
Yep, that's a fantastic question. I'm not a policy expert. It's very obvious to everyone that it's inappropriate for conflict of interest for MPs to be in charge of it. So I'm extremely confident that if you had an in-depth discussion about it, you could come up with something very reasonable.
So well, I guess I'll leave it as a comment that it's very bizarre to me that you're engaging in this protest without the very basic answer to the first question that would come up in solving what you are seeking to protest. But I appreciate you appearing before the committee.